Good morning,
Yes,
good
please.
afternoon, and good evening, everyone. Thank you for joining us. My name is Shao, and I am a 2L student at Yonsei Law School, and I am the current president of Yonsei International Arbitration Association. It's a real honor to have the opportunity to host such an amazing event as a 24-year-old student studying law in South Korea. And on behalf of our association, I extend a warm welcome to all of you at the 2024 Yonsei Arbitration Day. The YAD is an event that we are all very proud of. It holds quite a special place in our hearts. The YAD is unique in that it is Asia's first pioneering student-organized annual arbitration conference. This is the 5th annual YAD, and we aim to establish a platform for distinguished scholars, practitioners, and students worldwide to learn, communicate, and expand their thoughts. Our long-term goal is to ignite inspiration that can influence the field's future trajectory. This year's YAD features 2 panel discussions. As you have all seen in our flyer, we have assembled leading experts from all across the globe for each topic. First, we'll delve into the rising conflicts among leading energy sectors, exploring how these critical disputes intersect with global energy markets and arbitration practices shaping the future landscape of dispute resolution. The second session is called Tips for Young Practitioners, Foundations and Pathways in International Arbitration. I hope the audience will be able to gain invaluable advice from the best professionals in the field. Before we begin, a heartfelt thank you is to our esteemed institutional partners, HKIAC, SIAC, and Peter&Kim. Their support has truly made this event possible. Now, to begin, it is my distinct pleasure to introduce Mr. Kim, founder and managing partner at Peter&Kim in Seoul, for the opening remarks. He needs no introduction, but to be brief, he has been a pioneer in international arbitration in South Korea for the past 30 years and is one of the most respected figures in Asian arbitration. As I extend my gratitude for his contribution to this event, please join me in welcoming Mr. Kim to the stage.
Thank you for kind introduction. I hope I can say a bit, but 10 minutes is okay, or
Perfectly fine.
Okay, thank you. Maybe I over prepared. First of all, it's my distinct honor to be here and to share my perspective with some next generation and arbitration readers. I must say I will try, but not guarantee fulfill the assignment actually given by the organizer, like providing visionary insight. But I think it's a very good topic. I will try to just give you a bit longer version of my personal background, if you okay with me, and with some themes that I really try to contribute that one of today's theme, the tips for young practitioners, foundations and pathways in international arbitration. What I want to say basically is I want to observe that sometimes it is our unexpected detours or departures from the standard path that ultimately provide the most valuable lessons or define our careers. My story started when I was a teenager in late 1970s and early 80s. At that time, the Korean economy was booming. So one career path I considered was becoming a businessman. But ultimately, I decided to study law. So I went to Seoul National University, studied down that route. But along the way, I developed an unexpected interest outside the classroom. It's like something like the minor detour. So I joined the pistol shooting team at the Seoul National University. As you may witness at the recent Olympics in Paris, the Koreans are quite good at using metal weapons, the swords for fencing, modern bows for archery, and pistol for shooting. So my simple-minded theory is that the root of Korean skill with metals is their use of metal chopsticks. But seriously, in the sports of shooting, the main difficulty lies in keeping your hands and mind steady despite the various physical forces and the mental pressure pushing at you from all sides. It may look easy, especially if you watch the most elite Korean Olympians, but I can assure that it's not easy. So likewise, when you watch TV shows where the litigators set a trap on a witness, and sure enough, they fell right into the trap in the classic the gotcha moment. It looks so easy, but in near world of high-stake international arbitrations, such a moments may happen from time to time, but only because the counsels cross-examine the witness, spend hours and hours preparing for various scenarios that could arise. Being involved in my college detour and the shooting teams taught me a value of concentration and steadiness, and perhaps most of all, practice. So tip number one, as wise man once said, by failing to prepare, you are preparing to fail. To keep your heart and mind steady in those heated moments of cross-examination, or during oral opening submissions, or even written submissions, you need to focus like sharpshooter on target and practice with dog persistence. In context, this means finding, highlighting evidence to prove your case theory. So back to my story. After university, I did not attempt to join the Korean Olympic shooting team. Which is the Olympic was actually in 1988 when I became a lawyer. So I took a professional, more conventional career path and then became a Korean lawyer. That was about 36 years ago. I knew I wanted to do something international, but wasn't sure exactly what. So that's why I first became a corporate lawyer. Then first my work involved M&A, investment project, contract drafting, and then I got involved in some international litigation, particularly the insurance and shipping dispute. At that time, it's very common in Korea. The 5 years practice of law, I went to LLM at Harvard Law School, and then the practice in New York and London after that. So when I came back to Korea in 1996, just a year after we had financial crisis in Korea, 1997. So during this period, numerous transactions took place, and that transaction became a dispute. That is international arbitration. So in the late 90s, I was asked to participate in my first international arbitration. As I got more involved in the case, it seems like it's really giant professional detour. I was not sure how worthwhile it would be for my career. So initially, I didn't like the idea, but I soon realized that international arbitration is a fascinating area of law, and Korean law can play a very important role in those cases. So I decided to have established a practice group, and I want to start a separate practice group for international arbitration. So, and then many people say, "Oh, you will not have enough case. There's no market. Your English is not good enough." So, it's quite difficult to persuade my colleagues within the firm. So the tip number 2 is that your detour can sometimes turn into new career pathway. Don't be afraid of this. Just be alert. And once you find the opportunity, very flexible and adaptive. Getting back to my story, I read arbitration practice group, one of Korea's largest law firm for over 20 years. That was the first international arbitration practice group in Korea. I was quite lucky to have a number of cases, and we have good results, and team got bigger and bigger. So eventually, I realized that the best way to ensure the Korean arbitration market will expand is to encourage the competing law firms in Korea to start their own international arbitration practice group. Again, our firm colleagues strongly opposed the idea the creating new arbitration competitors in Korea. Didn't understand why I was doing this. So I explained that if you want to buy shoes, you go to department store, not a single shop. Likewise, if you want to eat, you go to the street with lots of restaurants. So my simple-minded idea that the arbitration community will make difference. So what happened was it actually happens. We hosted big arbitration conferences and we arbitration market in international arbitration. So the tip 3 is that don't be short-sighted. Your competitors today may be your partner of tomorrow. Working together with professionalism, maintaining good retainers with others, arbitration community was key, helped expand the pie in the long run. My next part of my story is that true inflection point happens. Around 2019, I began thinking about starting my own boutique international arbitration law firm for various reasons. But to my absolute surprise, I got a call. I was in Paris from Dr. Peter, who is famous Swiss arbitration attorney and long-time friend of mine. He said, let's meet for dinner in Paris. I said, sure. And over the dinner, he said, maybe we can start something together. So this is something I never thought about before, the Swiss-Korea combination. But I thought it might make sense. So 2 countries are both relatively small, neutral, internationally oriented, the civil law countries. So I just agreed. So that's how we started Peter&Kim, and our firm is now 100% focusing on international arbitration. It is we now have offices in other places, and then after the COVID period, just a few years, we are quite lucky to survive and have a good practice. I live in Seoul and learned the firm from our Seoul office, but I'm out of the country around 180 days. So the half in Korea, half in outside Korea. The core reason I started Peter&Kim is that I'm very interested in the market in Asia. Still the gap needs to be fulfilled. Most countries in Asia allow follow the similar tradition, and most share the similar cultures. The central idea is to assist the Korean Asian parties and parties with the business in Asia have proper representation by counsel who understand Asian culture and Asian civil law. So my final tip is, after you accumulate some experience, don't be afraid detour or depart into the specialty area where you realized gap exists in the market. So maybe for you, you'll be specializing in particular type of arbitration, such as energy arbitration, which is another topic of discussion for today. If you have faith and persistence, you are on the right path. You will have potential to become a unique and successful career path for you. In closing, I wish you a productive conference, and I encourage you take the bold steps to further enhance the arbitration market and secure your future. Thank you very much.
Thank you, Mr. Kim, for your kind and inspirational words. We believe that your insights will greatly enhance our understanding and guide us in navigating the world of international arbitration. Before we jump into the discussions, please note that a Q&A button is available on your screens. We encourage attendees to share their questions, which our moderators will consider during the panel discussions. Let's now kick off our first session. I would like to begin by introducing our moderator for session 1, Ms. Hana Lee. She is a proud alumna of Yonsei Law School, currently a partner at Lee & Co., and brings extensive experience as counsel in arbitration cases under the rules of leading institutions. Please welcome Ms. Kim to the stage.
Thank you, Sayam, for your kind introduction. I'm very pleased and honored to welcome everyone to the first session on this timely and interesting topic, rising conflicts among leading energy sectors. Today, we have 3 distinguished panelists. Our first speaker will be Mr. Joshua Simmons. He's a partner at Wiley Rein. He's a fellow of the Chartered Institute of Arbitrators and a FINRA arbitrator. In addition to his practice, he also teaches international arbitration at the University of Virginia School of Law. Prior to joining Wiley, Mr. Simmons practiced international arbitration at Covington & Burling and 3 Crowns, and also served in the Office of the Legal Advisor at the U.S. Department of State. Following Mr. Simmons will be Ms. Laura Abrahamson. She is a full-time arbitrator and mediator with the Judicial Arbitration and Mediation Services. She is a fellow of the Chartered Institute of Arbitrators, a board member of the SIAC's North American branch, and a vice president of California Arbitration. Prior to joining GEMS, she served as senior vice president, deputy general counsel, and global head of litigation at ACOM, an American multinational firm. And before that, she spent nearly 20 years in-house at Occidental Petroleum. And our last speaker will be Ms. Una Cho. Ms. Cho is senior foreign attorney in the international arbitration and cross-border litigation practice at Kim & Chang. Prior to joining Kim & Chang, Ms. Cho practiced for several years in the international arbitration at Wiley case in New York, and also practiced in Hong Kong and Shanghai at other international law firms. In addition to her practice, she also taught international business at Hanguk University of Foreign Studies. So without further ado, I'll give the floor to our first speaker, Mr. Simmons. Mr. Simmons, whenever you're ready.
Thank you so much for the kind introduction, and it's a pleasure to be with all of you across space and different time zones. And I am looking forward to kicking off our discussion about renewable energy. I think what I hope to do is to give you a couple concrete examples, something that I think can help everyone understand how renewable energy fits in with arbitration. But before I do that, as I think Kevin said well, it is helpful to think about different sectors as you're considering an approach to arbitration. And energy has historically been one of the most important, significant areas for global disputes. Why is that? Well, they're big international investments. Energy is critical to the daily life of humans all around the world. And in the past, a lot of the cases had a potentially straightforward fact pattern. So for example, when I began my career, we brought an investor state case against Venezuela because the government had expropriated major oil production facilities. That's a classic international arbitration scenario. Expropriation, straightforward claim by an international investor against a government. I think what we're seeing with renewable energy is that it's getting more complicated. The issues can be more complex. It's not going, you could still have a straightforward expropriation, but that's not the typical fact pattern. And partly that is related to the incentives that are so often present from the government for renewable energy. So that's going to be the theme I want to pick up on, is these government incentives and how they can lead to disputes, and then also how arbitration can effectively resolve those disputes. So the first example comes from Spain. Spain is now somewhat notorious in the international arbitration field because of the number of cases that have been brought against Spain over the past 10 or 15 years. And here's why. In 2007, Spain passed a number of laws passed regulations that incentivize investments in renewable energy, and in particular in the solar industry. So many companies invested in the Spanish solar market, and a lot of these were companies coming from other countries. So this is an international flow of capital into Spain to build up their solar power production capabilities. The problem came a few years later when those incentives that the government had passed turned out to not have the right economic fit for the government at that time. There was a financial crisis, and the Spanish government was paying a lot of money under these regulations. So Spain changed the way that it approached the regulation. And to make this very simple, that change by the government meant that the investors in the solar power industry were not recovering the same profits. They were not generating the profits that they expected when they invested. They didn't have the same terms that Spain had promised when they invested. So at least 40 different international investors brought claims against Spain. And what's been very interesting is that those claims, I mentioned at the beginning, the classic energy expropriation type case. These cases were not that. They were more complicated. The arguments tend to be that there was a violation of the fair and equitable treatment requirement, and that's a question of what were the legitimate expectations of the investor. These are terms that are found in international investment treaties. A lot of these cases arose in particular under the Energy Charter Treaty. And it turns out there wasn't a clear answer. And we know that now because different arbitrators came to different conclusions. Very similar facts. Some arbitrators said this is not a violation of fair and equitable treatment. Others said it is a violation. So there was some discrepancy in the case law, and that has been swept into some of the broader criticisms of investor-state arbitration over the past 10 years. But even then, and this is a recent development from just the past week, even in the cases where investors won, sometimes hundreds of millions of dollars against the government of Spain, Spain has resisted enforcement of those awards, has challenged the awards in the courts. Some of those challenges have gone on in my home territory. So I'm based in Washington, D.C., and we've had cases where completely foreign parties. So one of the cases is a Luxembourg investor in Spain is now trying to enforce the award in Washington, D.C. So this goes a little to the, borders. You can cross a lot of borders with international arbitration, and the enforcement is here in Washington, D.C. And just last week, the D.C. Court of Appeals issued a decision that upheld the validity of these enforcement attempts. So Spain had argued that enforcement was not valid for complicated reasons under the Energy Charter Treaty. And so I think the question from the Spanish example is, has international arbitration worked? Is it going to properly incentivize and protect international investment in renewable energy going forward? And that's a moving target, and I think one that's complicated, particularly when it comes to investor-state arbitration. Happy to answer questions about that. It's a complicated area, but let me give, as my second example, one that's closer to home for perhaps this group, and this one arises out of Korea. This is, as many of you may know, Korea, as the South Korean government has a strong policy in favor of renewable energy, and in particular for fuel cell technology, fuel cell energy. South Korea requires its large electricity producers to generate a large portion of their total power using renewable energy, and the government gives twice as many credits. So companies receive renewable energy credits for the using renewables. They receive twice as many credits for using fuel cell energy than even solar power. So there's a major incentive in place by the South Korean government in favor of fuel cell technology. So what does that do? I think this is where from a business perspective, when a government has that type of incentive in place, it will attract international investment. And so international investors have invested in the fuel cell sector of South Korea. One of the cases that I was involved in related to, and thankfully a good portion of this, all that I'm saying is public because these were publicly traded companies. A lot of times, as many of you may know, international arbitration proceedings are confidential, and that has its own benefits in terms of effective resolution. But this case, these facts were public. We represented a company called Fuel Cell Energy, which is a US publicly traded company. And it entered into a series of license agreements with POSCO Energy. I suspect many of you have heard of POSCO. It's a major Korean conglomerate. So these two companies entered into a series of agreements to maximize or take advantage of the government incentive for fuel cell technology. And it worked well at the beginning, as many commercial relationships do. The idea was that Fuel Cell Energy would license its technology to POSCO Energy. POSCO, being the Korean company, knew the market and would market it and sell the technology in the Korean market. But as is all the case in international arbitration, things did not continue to go smoothly, and a number of disputes arose between the parties. And so major international arbitration proceedings began. A tip for anyone who's ever drafting an arbitration clause, try to have a consistent seat of arbitration. So in this case, we had one set of contracts that provided for arbitration in Singapore, and we had another set of contracts, same two parties, same issues, providing for arbitration in London. So we had to actually pursue the arbitration in two different forums, two different arbitral tribunals, all the same issues. It was a real challenge. It was a procedurally complex case, but because of the flexibility of arbitration procedurally, we were able to reach a settlement between the two parties. So this was a major global settlement of their disputes. We did not have to take the arbitration all the way to the end. And what it meant was that Fuel Cell Energy would continue to sell its technology and operate in South Korea, which it continued to do successfully. And I saw just a few months ago, new press release about Fuel Cell Energy's technology being used in South Korea, growing market, and things are still working well. So what's the lesson to learn from that? I think it's that arbitration is really important for all of these government incentivized programs. And it's important in a couple different ways. One, when foreign investors are looking to put their capital into another country, they want investment protections. And it's important to have that type of treaty protection, some predictability. It will encourage more renewable energy when there can be these protections for international investment. The second is that, and this is the much more common scenario, there will be more international business deals, more international business contracts to encourage renewable energy because of incentives like South Korea's fuel cell technology program. And arbitration is perfectly situated to help resolve those disputes because it's flexible. It can be, we were speaking before this conference began about, it can be more efficient. The parties can select an accelerated timeline. They can choose page limits. There are ways in which the parties can adapt the proceeding to the dispute. And with renewable energy, sometimes there's also complicated questions about technology. There's some cutting edge solar power technology or wind energy technology. And it might be that it's important to have an arbitrator who understands some of that technology and has done those types of disputes in the past. So there's a whole range of reasons why arbitration is critical to the success of renewable energy projects internationally. And I think for the younger lawyers who are attending, it's a helpful area if you're interested in energy, you're interested in arbitration. There will only be more investment. There will only be more contracts related to renewable energy. It is the next wave of these international investments. And so it's a great intersection with arbitration, and I think one that leads to a lot of fascinating cases, and happy to discuss any questions or field anything from there.
Thank you, Mr. Simmons. I would like to pose one question in relation to this. You said arbitration can offer reliable protection for investors against policy reversals, procedure-wise, but you have also mentioned discrepancy amongst arbitrators on the same disputed issues. You also mentioned Spain's attempt to refuse enforcement. So I was wondering, what are the difficulties the investors face in these cases in comparison to more traditional investment arbitration cases? Or what would be some of the standard defenses the government can raise in investment disputes if it has revoked the promised investment incentives? I know this is a very general question, but it would be interesting to hear about some of the paths the government can take.
That's a great question. I think I'll try to answer it somewhat narrowly with an example of those Spanish cases, because the government has a legitimate regulatory power. And when it is putting in place an incentive or changing that incentive, that is within the regulatory power of the government. And so it gets to be a complicated question about, well, what were the investors' expectations? What exactly does the fair and equitable treatment standard mean? And so governments can find a lot of protection in that. I think ultimately the best answer to your question, and I think more and more some of the major international companies that do a lot of these cross-border investments want more than a simple treaty protection. And if they're able to have a contract with the government or with a government agency directly that provides more detail about what are the expectations, what are the terms, that can provide a lot more predictability. I think the frustrations with investor-state arbitration are actually on both sides. I think investors have had a lot of frustrations, and I think states have too. And I think parties are increasingly looking to, I mentioned at the beginning, the classic case was the big international oil and gas investment. Well, the way that investment protection happened in the past was with a contract. The international investor would have a contract with the government or with the government agency. I think we'll see more of that to the extent we continue to see frustrations both by investors and states in investment arbitration. I hope that's helpful.
That was very helpful in understanding the fuller picture of the dispute, so thank you. I think it's now time to move on to our second speaker, Ms. Abrahamson. But just before that, I want to remind the audience to submit your questions using the Q&A question below, so I can relay the questions to our panelists at the end of the session. So Ms. Abrahamson, the floor is yours.
Thank you for the introduction. I think somebody's going to put up the slides I prepared for this talk. And if we can go to the second page, that would be great. Somebody doing that for us?
Could you just wait for like 1 minute, please? Thank you.
There we go. Okay, if you can go to page 2. Historically, as Mr. Simmons just mentioned, the energy sector has been one of the greatest contributors to international arbitration, and it continues to have an outsized impact. 30% of all international arbitrations filed with the ICC, LCIA, ICDR, and ICSID for the last 3 years were in the energy and construction sectors, just about evenly split between energy and construction. And I think it's important to look at them together because there is a huge overlap, as we'll talk about, between construction and energy disputes, because many of the construction disputes are construction of infrastructure related to energy projects throughout the world. So if you can go to the next slide, if you broaden the scope to look at, sorry, one back, to include the Singapore International Arbitration Center and the Hong Kong International Arbitration Center, the percentage of international arbitrations drops for energy and construction drops to about 25%, 14% energy and 14% construction and 11% energy. I didn't include the Korean commercial arbitration, the KCAB's annual data, because their annual report does not provide a sector breakdown for its international versus its domestic cases. The most recent comprehensive report reflecting current thinking on the future of international energy arbitrations, and in particular renewable energies and the energy transition, was the January 2023 published report of a survey conducted by Queen Mary University in London in conjunction with Pinson and Masons. And they had 900 respondents, a mixture of common and civil law backgrounds, of end users, arbitrators, counsel, intermediaries, and academics. And they looked really at 2 primary issues. What were the drivers of disputes in the energy field for arbitration, and how international arbitration can best adapt to serve the energy sector needs. And we're going to talk about that first point this morning. Looking at the report, if you can advance to the next page, you can see why energy disputes have been such a large percentage of international arbitration. Across all subsectors, arbitration was the most preferred form of dispute resolution. And I have to say, I wasn't that surprised after my 5 years of heading global disputes for ACON that the dispute resolution boards were relatively low in terms of the preference. Arbitration is the preferred dispute. 72% of end users see arbitration as very suitable for energy disputes. And when we talk about end users here, we're talking about people at energy corporations. So either the business or the in-house counsel are considered the end users. And they were asked to rank their preferences, 1, 2, 3 for different types of alternative dispute resolution. And arbitration was chosen first by 40% of the end users for energy infrastructure disputes. It was only chosen by 26% in climate change disputes as their first choice, but it still was the single largest option picked. And I think the reason for that is that energy users see arbitration. I can speak from my own experience having headed up arbitrations at Occidental Petroleum, a conventional energy company for 20 years. But we see arbitration as neutral, enforceable, and benefiting from the technical expertise of arbitrators. At the same time, I think that the end users in energy want to see innovation driving greater efficiency in arbitration and more early decision making. And I just thought it was interesting to note that in terms of the choice of seat, and these were answers that were given in the fall of 22, and the report was published in January 23. 49% selected London as their first choice of seat, and 14% selected Singapore as their first choice of seat. And then that Singapore choice was a significant increase from what people had previously perceived. If you want to go to the next slide, to identify what has driven international energy disputes over the last 5 years, participants overwhelmingly agree that infrastructure construction and supply chain issues are the primary causes of disputes that lead to arbitration in the energy industry, closely followed by price volatility of both raw materials and the energy supply. traditional oil and gas activities and government policy changes, as Mr. Simmons just talked about, particularly in the investor state realm. I think it's interesting to note here that development and use of new technologies, decommissioning, and energy transition were all relatively small in terms of what the users and all the survey respondents suggested were the causes of international energy disputes over the last 5 years. That's going to be very different, I think, moving forward. So if you move to the next slide, when you look at responses for what they expect to be drivers of international disputes over the next 5 years, you see energy transition, the development and use of new technology, climate change, and decommissioning all increase. And I think that if you look at a larger horizon of the 5 to 15 year, you're going to see them becoming even more important. One of the interesting things as we look forward to reducing our carbon footprint and we look to the rise of renewables is that it's important to realize that the traditional conventional energy disputes are not going away. Half of respondents expect traditional energy, oil and gas, upstream, midstream, and downstream to continue to be a source of energy disputes for the next 5 years. And the International Energy Agency expects oil demand to peak in 2030. So the types of historical energy disputes that we've had in the past are going to continue. And then on top of that, as the COP28 Global Stockholm Nations agreed on a roadmap for transitioning away from fossil fuels, calling on parties to triple renewable energy, this disruption in the market is going to continue to increase and widen the spectrum of energy disputes. There was a pretty significant conference earlier this year put on by the Institute for Energy, the Institute for Transnational Arbitration and the Institute for Energy Law, a joint conference they do every year. And one of the panelists said, our world as energy lawyers is going to get a lot bigger. And I think that is the largest probably takeaway here. If you go to the next slide, when people are asked which subsectors are expected to see the most energy transition disputes, you can see that power generation, renewables, nuclear, and hydrogen are all expected to play a role. As I mentioned, the conventional energy disputes, construction disputes, JV disputes for power, particularly generation, transmission, offtake disputes, and investment disputes are all going to continue to play a part. And before turning to renewables, because we're going to look at renewables separately, I want to talk for a moment about how a few additional types of disputes are likely to be seen in the areas of nuclear and hydrogen storage. So hydrogen is still in its infancy. When you look at the percentage of projects that have actually gone to investment, it's really very, very small. But as that takes off, in addition to the sort of typical disputes you see in energy, I would expect we're going to be seeing contractual disputes relating to specifications, whether the emission profile for hydrogen, the hydrogen products are correct, whether hydrogen is green versus blue. And in nuclear, we're seeing an increase in nuclear projects in the pipeline driven by increased awareness of carbon emissions and energy security issues. So nuclear brings with it its own set of additional problems because of the security issues, safety concerns involved with nuclear dynamics, the lengthy project schedules, and a type of regulatory burden that's more geared toward these safety and security issues than you see with typical energy projects, but which are likely to be a source of dispute going forward. So if we could advance to the next slide, when looking about what changes coming out of energy transition are likely to give rise to disputes, Mr. Simmons has just talked to us about the investor state impact of regulatory changes. Infrastructure construction is going to continue to be significant across energy disputes in the energy transition. As I said, we're going to talk about renewables more closely in a moment, but I wanted to point out here this phase out or construction of oil and gas and other fuel projects, together with, I think, it's often referred to as decommissioning. Decommissioning is going to be a significant source of energy disputes and arbitration going forward. There's an example out of the North Sea where there have been, a lot of oil and gas projects in the past, and the UK standard form contracts, which have been published for international use for these little, be it use in these decommissioning projects, have tiered dispute clauses leading to arbitration. So we're going to see with the decommissioning that being these oil and gas projects had to be a big issue going forward. Moving to renewables in the next slide, what I think strikes me the most is the design. Design uncertainty as newer technologies are brought to market is going to create operational risks, like we saw in wind and solar projects 10 years ago or more. An example from a non-energy source of a technology dispute is, there were a number of large, in my role as head of disputes for AECOM, we had some of these historical design arbitrations relating to the platforms for some of the wind projects, for some of the solar project design, things with the halt salt tanks I've seen. But with waste projects, organic waste projects, the biomass projects had huge operational risks that affected the industry. So we don't know exactly what those disputes are going to be, but I think as newer technology is brought to market, those operational delay risks are going to be a big factor in disputes. Regulatory disputes, we're looking both at the subsidies and pricing that Mr. Simmons talked about in terms of this, as governments change those, that leads to the investor state, but also delays in regulatory and planning approvals, which are closely related to supply chain and pricing issues. And I'm going to give you an example of that. In 2021, the US Customs stopped allowing imports from a key Chinese supplier of raw materials used in solar panels due to concerns about forced labor issues in one area of China in particular. This was closely on the heels of, the supply chain issues impacting everyone coming out of the pandemic, but it completely stopped, most solar panel production, or solar panels being allowed to come in out of customs at the ports in the United States. It was a major cause of delay for a lot of solar projects and led to significant price increases. And I actually served as the sole arbitrator in a large solar project dispute last year, where one of the issues of delay and price increases was this regulatory activity by the US Customs. If we go on to the next slide, I think a really interesting question for law students and for lawyers is, what can we be doing to mitigate some of the risks of the increased types of energy disputes are going to be heading to arbitration in the coming years? And the survey asked that question of its participants, and the respondents, first answer was reviewing contracts to make sure there's appropriate clauses for risk allocation, hardship, force majeure, and the dispute resolution processes. And the risk allocation point, I think, is really important. And the example I gave you a few moments ago, the case I presided over, the seller of the project had taken the risk of increased costs and delay in completing the project. And so when the US Customs shut down the import of solar panels, and it was also a key component in battery storage, the seller ended up with an unexpected huge financial burden, and didn't have the force majeure language that would have sealed that off or put that effectively to someone else. most US companies in the wake of that customs issue have started to put language into their solar panel contracts that require solar panel and battery suppliers and construction contractors to comply with the supply chain code of conduct, including allowing them to trace the source of the materials used in the products to make sure they don't come from that province in China, which still has the forced labor issues that are bothering the US government. And then, another quote from one of the panelists at the IEL ITA conference that I just thought was particularly apt to close the thinking on this morning before we go to questions is and you can advance to the next slide, if you will, that one of the most significant risks associated with the transition to clean generation of energy is the adoption of new technology. The pace of change and the government incentive schemes driving many projects are creating a focus on project delivery and completion, and contractors are often being required to deliver projects at ever-accelerated rates to satisfy incentive schemes requirements, and there are concerns that the new technology could that even newer technology could render projects obsolete. And with that, I'm happy to take any questions now or at the end of our session.
Thank you. That has been really helpful. I just would like to pose one question in relation to your presentation. You said one of the ways to mitigate some of the risk on the part of the end user, the most important thing is to write the contract correctly. And one of that is putting in the contract the right dispute resolution mechanism. And as an arbitrator and mediator, do you recommend that the parties implement multi-step dispute resolution process or result to more expedited process in terms of these technical disputes? Do you have any general idea in terms of how parties should draft their dispute resolution clause in comparison to other contractual relationships?
Yeah, I'm in favor of expedited procedures, and I'm particularly in favor of expedited procedures when you're in the for construction or completion of projects. So when the dispute relates to an issue that's impacting the ongoing development of a large energy project, like one of these solar projects, in England they have a system which is called adjudication, which when I headed up disputes at AECOM was something I was very fond of because, and I think we as arbitrators in the energy space can do a better job. And I think some of the institutions with their expedited rules are trying to do that. But essentially what England does with the adjudication is they've got a very tight timeline where if there's a dispute on an ongoing project, I think you have to file your claim within 6 weeks. There's 6 weeks to respond to it. And then again, within either a month or 6 weeks, the adjudicator has to render a decision. So the entire time from filing to getting a decision is right around the 3-month mark. It's not binding. So the parties can go back at the end and they can they can fight about it all over again, but it keeps the project going and it keeps the money flowing and it allows the project to continue. I think one of the ideas behind dispute resolution boards is that they would similarly help projects continue to move and not have them held up for 2 years or 3 years while various disputes were going on between the parties. I think, in my experience, those were not as effective as this adjudication procedure in England was. And oftentimes by the time people got done with the project, the sort of quick and dirty answer was sufficient for them, that they did not feel the need to go back and reopen and relitigate things. And I think that, expedited arbitration procedures could be used by parties similarly. And I think if you've got a project that's ongoing, you desperately need an expedited procedure because getting an answer 2 or 3 years down the road is not going to help when you are in the middle of developing one of these renewable energy projects.
Thank you. Thank you for that answer. And since we have some time left, I just have one more question. Do you agree that estimating damages in these cases are more difficult as they may involve new technologies and new system of contracts? And do you agree with this conception that arbitrators in these cases sometimes try to just split the baby instead of going through all those like damages claims and estimations? What are your thoughts on that? And what are your advice to practitioners?
I don't think that arbitrators try and split the baby. I do think that there are significant damage questions that come up with new technologies because, to the extent that someone's wanting to get lost profits as an element of their damages, they've got to be able to prove those lost profits. Meaning, different legal systems have different particular formulations of it, but there's generally accepted an idea that damages have to be relatively certain to be awarded. And when you've got new technologies, that can be a huge issue. So I think that the issue with new technologies and damages, and that operational risk I was talking about is more, how are you going to measure what, you can know what your increased construction costs are. When the U.S. Customs stops the import of the solar panels and they have to go to another supplier and the price goes up by 30%, that's a number that can be calculated and ascertained. If the project doesn't meet its deadline for completion, and so you've got an offtake contract with the electrical grid of a city, and there's delay damages or liquidated damages in that contract, you know what that number is. But the sort of lost profits part, you don't. There's a real issue of whether you're going to be able to prove those damages. So I don't really think it's a matter of arbitrators splitting the baby. I think there is a real question with the calculation. And, on your question a few moments ago about the tiered dispute resolution, I think there's a time and a place for tiered dispute resolution clauses, but there's two things people need to be aware of. One, you have to make sure that your tiered dispute resolution clause does not create a jurisdictional trap. And what I mean by that is if you require the meeting followed by executive meeting followed by mediation followed by arbitration, and you don't have an outwritten in, so such as within 2 weeks they agree to meet with executives, and if they don't do that, people can go to mediation. They're going to mediate within a month, and if they fail to mediate within that time, you can go straight to arbitration. Then what you create is the ability for one person to hold up the arbitration and potentially divest the arbitrator of jurisdiction. Because if somebody hasn't complied, it becomes a condition precedent, and if you don't comply with it, then you risk jurisdiction of the arbitrator. So I think you have to be very careful in drafting. The other thing is, while mediation, I think, is incredibly important and is often advantageous, the question is, when is mediation advantageous? In my experience with energy infrastructure construction disputes, at the beginning of a dispute, I would hear from my clients that they hadn't done anything wrong, that fault was all the other sides, and they were fairly convinced of their own opinions, and so it was rare that we got the case settled at that pre-arbitration mediation stage. Instead, once the arbitration gets filed and gets going, I think mediation can be more effective once the parties have, particularly in international arbitration, where their evidence goes in with their memorial, their witness statements, their documents. Once you see the other side's evidence, then you might mediate and save the cost and delay of the hearing and getting to a written award. But I think mediation is a useful tool. I'm not sure it's always useful in the sort of with the way that tiered dispute clauses are normally written. I don't know if Mr. Simmons has any viewpoint on that.
Sorry, no, coming off of mute. No, I think the tiered resolution, I think that's a perfect analysis. I agree.
Thank you. That was really, really helpful for me as a practitioner and also to the audience who are aspiring lawyers in the arbitration field. And so last but not least, we have our last speaker, Ms. Una Cho. Ms. Una Cho, the floor is yours.
Good morning, everyone. I'm honored that I've been asked to speak in front of you at my alma mater. Thank you to the organizers of the Yonsei Arbitration Day. It's very nice to be with you in spirit, if not physically. I do have a PPT, which I had not have a.
I express my greatest gratitude to our panelists, Mr. Simmons, Ms. Abrahamson, Ms. Cho, and our moderator, Ms. Lee. The insights they have shared truly inspired me and have elevated level of my understanding on this important and delicate topic. I am certain the audience would have felt the same. A brief intermission is upon us before we move on to our second session. We will recommence in about 4 minutes at 11:30 a.m. KST. Welcome back, everyone. It's time for our second session, Tips for Young Practitioners, Foundations and Pathways in International Arbitration. Our moderator for this session is Ms. Sangjin Lee from Kim & Lee. As a former president of the Yonsei International Arbitration Association and a co-host of YAD 3 years ago, she returns to this event as an associate, making her the perfect moderator to guide us through the session. Please welcome Ms. Lee.
Thank you for the introduction, Taeyeon. Good morning, good afternoon, and good evening to everyone joining us from around the world. I'm Sangjin Lee from Peter&Kim Lee, and it's my pleasure to welcome you to our second session, Tips for Young Practitioners, Foundations and Pathways in International Arbitration. We have an outstanding panel today ready to share their invaluable experience and advice with young practitioners. First, I'd like to introduce Mr. David Kim, a partner in the International Arbitration Team at Baker McKenzie and KO Partners based in Korea office. Our second speaker is Ms. Dianna Shao, a consultant in Clifford Chance's litigation and dispute resolution practice in Hong Kong. Next, we will hear from Mr. Justin Yuen, a partner in the litigation and dispute resolution department at Deacons in Hong Kong. And last but not least, we have Mr. Yong Chen, Counsel in Freshfields Bruckhaus Deringer's International Arbitration Group based in Singapore. Before we begin, I'd like to remind our audience to submit any live questions through the Q&A poll during the presentations. Each panelist will address questions at the end of their presentation, providing a valuable opportunity for students to gain further insights. Without further ado, it's my great pleasure to invite Mr. David Kim to start us off with his presentation on escape velocity, practical tips on how to survive and thrive in the field of international arbitration. David, the floor is yours.
Thank you very much, Ms. Lee. It's a pleasure to be here today to speak on this topic. Really impressed with the organization of the Yonsei Arbitration Day thus far, and of course the first panel speakers were excellent, and I'm looking forward to speaking on this topic today. If I can just find my notes, there they are. So today I found this topic to be very interesting because out of all the many years I've been asked to speak, there's never been one that's so directed at young practitioners, those either starting out or still in school. And so I found this topic very interesting, mainly because I'd wished someone had given a topic or discussed this back when I'd first joined the arbitration field, 2 decades ago. So before I sort of give you my 3 points of wisdom, the first thing I'd like to share is if you want to, or you're currently pursuing a career in arbitration, then you've definitely taken the narrow, more difficult path. It's one of the few areas of law where it's an equal playing field around the world. A complete, competent, and sophisticated lawyer in Singapore can compete against a lawyer from New York or Korea, and there's very little geofencing or boundaries that prevents it. So congratulations, you picked one of the most competitive fields in the world. That being said, it's also one of the most rewarding, and you get a chance to meet amazing people. And let's face it, if you're in corporate or in tax, after a while, every share purchase agreement looks the same. Whereas out of the dozens or hundreds of cases that we've all dealt with, you can never really say one is exactly the same as the other. And so what would be my first piece of advice? Well, I wanted to say give up, go home, join tax or corporate, but I was told that wouldn't be helpful. So instead, I'll give you 3 points that at least for me, I'd wished I'd known when I first started out in this career. The first is that you are responsible for you. And that sounds pretty obvious, but what I mean by that is, perhaps I'll give an example. Even the most ardent sports fans have probably never heard of Rich Paul, Jeff Jackson, Jorge Messi, or Tony Godsick. But at the same time, I'm sure you've all heard of LeBron James, probably one of the best basketball players of all times. Connor McDavid, still in his prime, but also considered one of the best hockey players to have ever lived. Lionel Messi, who's a fantastic football or soccer player for you Americans. And Tony Godsick is the agent for Roger Federer. And so these are all agents. They all negotiate player salaries. They become their brand ambassador. They promote them and they convince others that they are worth it. And this is why they are in high demand on every magazine or television ad, and why that they are a quality athlete. The harsh truth is that as lawyers, for the most part, we do not have agents. And if you do, you're very rich and very lucky. So you are your own agent. You are your own brand ambassador. So my advice is that you need to be able to take responsibility and ownership for you. And so, of course, your firm, or whether it's your company or the institution you work for, they will do their best to assist. But at the end of the day, you are responsible for you. So what does that practically mean? Well, as everybody on this call probably knows, there's one thing that arbitration does not have a shortage of. It's conferences. There's pretty much one every week, if not every month. And so what separates our field from others, such as our brethren in the tax or corporate fields, is that we've got plenty of conferences. And for the most part, they are free to attend. And so I encourage you guys to attend them. The fact that you've taken time out of your day to join this Yonsei Arbitration Day virtually means you're on the right track. And you don't really have to go very far. I believe there's a HKIAC conference being held in a couple weeks. And of course, we have our annual Seoul Arbitration Festival. But don't let the name fool you. It's still a conference. The second thing I would suggest is to sign up for memberships. You know, currently we've got the Yonsei International Arbitration Association. For those who are able to apply to that, I suggest you do if you haven't already. But there are countless institutions that have memberships available for young, like-minded arbitration practitioners, such as Young ICA, KCAB Next, ICC-YAAF, HK45, and Young SIAC. So my advice is, because when you come out of law school, many people seem to believe that all you have to do is put your head down and work hard behind a desk, just become a keyboard warrior. That is important, but it's not the entire recipe for success. It is important, but not the only one. And in fact, from my point of view, it's the bare minimum. You are all bright. You've beaten your peers to get to this level in life, whether that's as a first year or junior associate, or whether it's at a top-notch law school. So working hard is a given, but it's not enough. And unfortunately, working hard will also lead to failure. And the hard truth is that you can do your best, you can give it your all, and you can still lose. And that's my second point. That is the nature of arbitration. For the most part, you have a successful party and an unsuccessful one. You'll have, more often than not, unfortunately, times where the tribunal will try and split the baby, so to speak. But generally speaking, you do have a winner and a loser. And so to put this into context for those who are aspiring to join law firms, it's still a business. And so mentoring and coaching can sometimes be hard to come by. And so I remember when I first graduated law school and I passed the bar, the head of litigation came to me and said, "Congratulations, David, you passed the bar. Now you know everything." And he said it with a sarcastic tone, but I didn't quite understand what he meant. The point is, as a junior lawyer, you're no longer protected by the confines of school. You're going to be held by the same standards of any other lawyer, albeit on a junior one. And so you will make mistakes. I know I did, and I continue to do so. And this might be a difficult concept for many of you who've graduated top of your class, who've excelled in everything you've done. When you go into the real world, there will be failures. You will receive criticism, many times from your seniors, but sometimes, and unfortunately worse, from your clients. And the sting of a loss can be very, very long lasting, especially if you believed that you were going to be successful in the outcome. But this is where I think it's important to understand that you can't let your failures dictate your career path. And Roger Federer is one of my favorite tennis players. He's now retired. He gave a very impassioned speech at Dartmouth, commencement speech. And he had said that he was talking about how historically he had won 80% of all his matches, but on a per shot basis, he had only been successful 54%. And so he said something that's really stuck with me, which is at that moment, that next shot is the most important shot that you'll ever take. But once that shot is over, the next shot becomes the most important shot you ever take. And I think that's a healthy way to look at your career in arbitration. There will be times where you meet failures, where you are unsuccessful, but you have to understand that that is over now and you can't dwell on it too much, and you have to move on and you have to proceed and face the next challenge as the most important one. On that point, there's something that Elon Musk said a few months ago, if I recall. He was asked about failure, and he was speaking about SpaceX and about how the first 3 launches into space were failures. They essentially exploded midair, and if they didn't get it done on the 4th one, they'd essentially go bankrupt the very next day. But when he was asked about it, he said failure is irrelevant, and I think that is true. It is irrelevant, but then he immediately said it's irrelevant until it's catastrophic. So failure is irrelevant until it's catastrophic. But that leads me to my last piece of advice, which is you get to decide what is catastrophic. And what I mean by that is, yeah, if you were to do something very poorly and it led to you getting maybe fired or laid off or something like that, yeah, in many people's eyes, including your own, that might feel like catastrophic. But you still have a long career ahead of you, and you can rebuild your practice, you can rebuild wherever you started off from. So don't give up. And that again leads to my 3rd point, which is the title of this talk, which is escape velocity. Now, for those of you who are into physics or like spaceships, escape velocity just refers to the minimum amount of force or speed needed for an object to escape Earth's gravitational pull, and so that you can now go into space without being falling back to Earth. For those who are curious, that's about 25,000 miles per hour, which is about 40,000 kilometers per hour. The reason why I titled this is you need to escape the lawyer's version of gravity to become what I like to think a successful practitioner. Now, sometimes people get lost in what the concept of gravity is. We all know it's 9.81 meters per second, but when it comes to your career path, gravity is not your nemesis in college or your peers or someone in a competitor's law firm or even those within your own firm. Gravity in this instance, from my point of view, is actually you. The only one that's holding you back from being successful is you. And so if you can take ownership, if you can understand that failure isn't the be all and end all, then you'll be all right. And whereas most discussions end on a high note, I'll end on a sobering one. For the vast majority of you, you have, at a bare minimum, 30 years of work ahead of you, whether that's at an institution or a law firm. That's a really long time. For some of you, you might not even be 30 years old. And so please remember this, you only get one reputation, and so you should protect it. You should not be tempted to trade it in for cheating or backstabbing or lying or doing anything that you wouldn't be proud of. It's just not worth it, because for the next 30 years, that reputation will stick with you. So I'm conscious of the time, so perhaps I'll pause here and pass it over to Ms. Lee. Thank you.
Thank you, David, for your very helpful advice. I also watched Federer's speech recently and found it incredibly inspiring. So I agree that taking ownership of your work is very important. But as a junior myself, I think managing my time and handling stress is crucial in order to do so. Do you have any tips on how to excel in those areas or your personal advices?
It's a very good question, and unfortunately, I think we've all been lulled into this false concept of work-life balance. It's very difficult if you've chosen to work at a top-tier law firm in any country, and you expect it to be a walk in the park, then you've been lied to. It's very hard. Attrition is real, and it's very difficult. But the one thing I always tell my associates, and it's sort of it's something that I've sort of held dearly, is at the end of the day, family is everything. And so whether family means your parents, your pet dog, or your wife and children, family is everything. So at the end of the day, work is a means to achieve that. But if you sacrifice your health, if you sacrifice your family in exchange for a quote unquote successful life in a law firm, then I think you're doing it wrong. The reason why we work this hard, of course, is because we enjoy what we do. And for the lucky of us, we get paid quite well for it. But you really do. And this is why it's impossible to give a clear answer. There is no black or white or binary answer. But I would say if you can always remember that a law firm is a business and family is everything, then hopefully that will guide you towards, where you need to put in efforts and where you need to sort of pull back, because stress is a real thing, especially in our profession.
Thank you. Audiences, just a reminder, please feel free to ask any questions through the Q&A poll in the underbar of our Zoom screen. Now, we'll move on to our next speaker, Ms. Dianna Shao. Dianna, over to you.
Thank you, Ms. Lee, and thank you also for organizing this conference and for the opportunity to speak with the students today. So the topic for me is foundations and pathways to international arbitration. I think a lot of the speakers will all be speaking to quite similar things, and I think some of the things that I'll be speaking to in the next couple of minutes will echo what Mr. David Kim said earlier as well. So in terms of the structure for my presentation, because of the theme, I've sort of separated it into two interrelated topics. The first is foundations, and what I mean by that is, what do you need to get right, whether it's out of law school or as a junior lawyer, to succeed? What are the foundation building blocks for that? And then secondly, what are some of the pathways for paving a way into a career in international arbitration? So I'll start with the first topic, which is foundations. And here I think there are three things: legal skills, professional competencies, and also characteristics. And I'll talk about each of them in turn. So with legal skills, what I mean by this is honing basic lawyering skills like research, legal writing, drafting, and also trial advocacy if you ever have the opportunity to watch it in action or to practice it. These are all neutral skills. And what I mean by that is they're not something that's specific to arbitration. If you can build and develop these and hone these skills, it will put you in good stead for whatever it is, whatever specialization you choose as a lawyer, particularly as a disputes lawyer. So research skills, I don't think I need to explain what they are. Research skills are particularly important for junior lawyers. So as a junior lawyer, if you're starting out at a law firm, those are often the tasks that you're given. And so if you can find, if you can develop your research skills and do it in an efficient way, you'll find yourself in a good position as a junior lawyer. Legal drafting. Legal drafting is perhaps one of the most important skills you'll need as a lawyer. It's something that you'll need no matter what specialization you go into, whether it's disputes or whether it's something else. We see lawyers on television in sort of TV shows, and you see them perform in court, and that's the image that you get of a lawyer. But the reality is that the vast majority of lawyers spend far more time writing than they do on oral arguments. And so if you want to take action now that will help you become a better lawyer in the future, focus on sharpening your writing skills. And this is something that you will develop over time. It's not something that you will get right the first time. I'm still working on drafting skills, and it's something that you will continually work on, making your writing clear, concise, and succinct, but it's something to be mindful of. And then I think also pursuing litigation experience. If you have the opportunity to watch practitioners in action, if you're able to watch lawyers do advocacy in action, go and watch them, because you'll learn a lot in the process of watching as well. Then we get onto professional competencies. And what I mean by that are the soft skills, which are just as important, if not even more important sometimes, than the legal skills that I talked about earlier, particularly for a junior associate. So this boils down to, how reliable are you as a junior team member in the law firms or in whichever firms that it is that you go on to work for? So what I mean by these are organization skills. Can you look after a particular work stream, manage your time in relation to a particular work stream? So as a junior lawyer, a lot of the time what you might be asked to do if you're in disputes arbitration is, for example, put together documentary exhibits for a particular submission, which involves getting yourself involved, learning how to do footnoting, and then getting on top of all of the documents, knowing where all of the documents are. It sounds like something that's very, very simple, but your ability to get on top of all of the documents is really, really invaluable, and your seniors will find that to be really, really invaluable as well. Communication skills. Communication skills are important for lawyers, full stop. It's one of the most important qualities and skills that we need to get right. But as a junior lawyer, it's simple things, right? It's things like, do you know how to communicate to different people in different contexts? Managing communications within your internal team, letting people know where you're at. If you need an extension, let people know earlier rather than later. Don't tell people at the 11th hour. And then just allowing people within your team to know exactly where you're at. Also, attention to detail. It's something that I think is very important for a junior lawyer. Sometimes it's all about perception as well. If people think that you have good attention to detail, we all slip up from time to time, right? But if you really place emphasis on getting things right and making sure things like checking your emails when you send them out to make sure that there's no spelling mistakes and things like that, when people have a perception of you as somebody who has good attention to detail, that'll stick with you over time. And so if it is the case that you make a mistake later on, that's okay, because people already have that perception of you. And so it sort of allows you a little bit of a buffer to make mistakes later on as well. Then we get to the third foundation quality, which is characteristics. And what I mean by that are things, qualities that we look for in a lawyer. And I think Mr. Kim touched on that as well in his section. So what I mean is integrity and trustworthiness. I don't think I need to explain why integrity and trustworthiness are very important for lawyers, but in international arbitration, your reputation is everything. This applies to the quality of the work product that you produce, but also your professionalism, how you come across to others, and the way that you interact with others, and also your integrity. The other point is commitment and perseverance. I think there's no getting around this. The law is a tough field. Practicing law can be one of the most rewarding and meaningful careers, but it's also a lot of work. As is true for any profession, success requires effort. There will be really difficult days. You will be stuck dealing with a client who's making, sometimes they can make your life unnecessarily hard. Sometimes you will come across people, whether it's on the opposing side or in some other context, who is being, unhelpful, sometimes rude even, for no particular reason. A judge or an arbitrator could rule in the wrong way on a particular issue that you think or believe you should have won on. Or you may simply just feel really overwhelmed, frustrated at a particular time. Or maybe it's the case that you made a mistake. That happens, right? People make mistakes. I've made mistakes. I'll continue to make mistakes. It's all a part of the job, and it will happen. But I think what will set you apart as a successful lawyer is your ability to persevere, your ability to just work through the challenges, to work through the challenging times, to get to the rewarding and the meaningful moments. Having longevity in this career is as much about your ability to persevere through the hard times and not letting things get you down as it is about how brilliant your technical skills are. So moving on to pathways. What are some of the pathways and some of the things to keep in mind if you want to pave a career in international arbitration? I've got a few points here. The first is be flexible and to keep an open mind. Positions at firms, and particularly firms with well-known international arbitration practices are hard to come by. And careers are not linear. Your career is not just a ladder, even though we refer to it as a career ladder. It's more like a jungle gym, right? What you see at a kid's playground. There's so many different pathways, and there's no one linear pathway that is right. And sometimes you have to create your own pathway. A private practice law firm is not the only way. There are arbitral institutions that you're able to work for. There are opportunities in academia. There's opportunities in government. There are intergovernmental organizations that you can also look into, or even perhaps NGOs or IGOs that have some sort of involvement in some form of arbitration work. There's lots of opportunities out there, so go out and explore them and find what those opportunities are. Go out, volunteer. Volunteer to write an article, help someone prepare for a conference, organize something, speak at something, even if it's to other fellow students or to younger students. Do internships and fellowships. The more you do, the more you learn, and the more people you come across, and the more opportunities will come your way. Get involved. Don't assume that if you're good at your work and you sit at your office that somebody will necessarily notice you. Just working hard and keeping your head down is not enough. Get out there and let people know who you are. Meet people and let them know who you are and build relationships. Get involved in young arbitration practitioners groups. It's a great way to meet fellow peers and also people who work in this field, and it's a great opportunity to learn about other opportunities that could be out there for you. Number 3 is finding a mentor. Now, what I mean by that is just identifying role models. If there's somebody who you've come across who you really admire, whether it's what they do or certain skills that they have, find ways to get in contact with them. But at the same time, it's great having a mentor, and it can be very, very helpful, but it's also not a failing if you don't have a mentor. Sometimes it's very, very hard, especially for a student or a junior lawyer, to go up to somebody and just say, will you be my mentor? It's a lot of pressure. And it's hard for mentors as well, because they need to think, well, I need to sort of set aside and I need to dedicate time and resources to this particular person. In the same way that you're not going to go up to somebody that you like and say, will you go out with me? Will you be my girlfriend or boyfriend? Or do you want to get married? That might be a little bit too strong and heavy, right? So you don't necessarily need to do that straight away. If you come across somebody, ask questions. And that takes the pressure off yourself and for that person as well. Ask them out for a coffee. Say, I would like to do A, B, and C. Would you have 10 minutes for a coffee or for a Zoom meeting for me to just get advice from you? That's a great opportunity for you to get your questions answered. Sometimes you don't know what you don't know. And so sometimes by speaking with people who might approach things from a different angle, you'll find that they might give you quite invaluable advice, whether it's career advice or some other form of advice that you will find useful. Then we get to the final point, which is being brave and finding your own path. Nobody cares more about your career than you. So having the confidence in yourself is incredibly important, because if you don't have the confidence, no one else will. Like I said, there are lots and lots of opportunities out there, and it's not just a linear path to a career in arbitration or to any other field that you're interested in. Go out and find the opportunities, and don't be afraid to put your hand up to do something. Similarly, don't limit yourself. If you're given the opportunity to do something, even if you feel like it's out of your depth, just do it. Sometimes we're not the best judges of our abilities. Sometimes others have a better idea of what we're competent of than we are, because sometimes we really do underestimate ourselves. So give it a go. What's the worst thing that could happen? You could just go back to doing what you were doing before. But if you give it a go, and you find that you might like something, or it might take you down a different path, I don't think it's something that you will regret. So, be confident, be brave, and go out and pave your own path. Thanks very much. That's my presentation.
Thank you, Diana. We have some questions from the audience. He or she asked that regarding how you gave your tips on trying to have a flexible and open mind, how do you balance such different perspectives and try to stay out of being trapped in only one ladder? How do you actually remind yourself that there is a jungle gym, not just a ladder?
Yeah, it's a really good question. I think as a junior lawyer, I think it's really hard because sometimes you're just trying to keep your head above water, right? I know as a junior lawyer, when I'm sort of the first 2 years of my career as a trainee lawyer, I'm just trying to figure out what's going on. But I think the thing to the one piece of advice is as hard as it is to just sort of manage your time, go out and try and meet people. Meet people in the field. It doesn't have to be sort of, at a particular event. Of course, if you're able to go and attend events, that's a great way to meet people. But it could also be, your clients. You'll come across people on your client side. And I don't mean you don't necessarily have to be best friends with a GC. That's a tall ask for a junior lawyer, right? But there's always going to be junior members of that team who you could get to know. Go out and meet people, and then build those relationships. It's really an organic process, right? So you don't have to go at it with a particular objective in mind. Sometimes it's just going out for a drink or a coffee with somebody just to get to know them. And in the process, and the more that you get to do it, and if you build up sort of a lot of these coffee dates, the more that you become better at it, and the more it's also an opportunity for you to get out and clear your mind as well, right? If you stay at your desk and just keep working at your desk with your head down, you're not really going to see everything that's out there. But if you really go out and meet people and do it in a genuine way, right? Try and really get to know them, try and help them. And in the same way that you try and help them and provide information to them, they will do the same to you. And in that process, that's how you go and get to know the other opportunities that are out there. I hope that answered the question.
Thank you, Diana. In the interest of time, we'll now move on to Mr. Justin Yuen, who will speak on how to start a career in international arbitration. Justin, the floor is yours.
Thank you so much. I'm not sure whether you can hear me. Yeah, you can hear me. Thank you so much. Okay, so good morning. It is indeed my pleasure to be able to speak to you today here. And actually, I find the sharings of David and Diana, they are so personal, and I think they are quite very useful to the students and young practitioners. And I hope, my sharing with you today will be likewise, be helpful to you. For the Korean audience, I think you may not heard of Deacons, my firm. Actually, Deacons is the oldest law firm in Hong Kong, and it was established in 1851. In other words, it has a history of 173 years, and we have about 200 lawyers in our Hong Kong office. Okay, back to the topic. To the law students and young practitioners, they may want to know how to get in the practice of international arbitration. Actually, there are a few ways where you can do so. The first one and the most natural one is to get in a law firm where they have the international arbitration practice. To me, I was able to join the law firm with arbitration practice. And at the beginning, I was involved in construction arbitration and also local arbitration. But as time goes by, I was able to have the opportunities to get involved in some other commercial arbitrations with international elements. In other words, foreign companies, they may have this bill, and in their contracts, they stipulate that they are going to, conduct arbitration in Hong Kong with Hong Kong law. So that's why I got the opportunities to work in those arbitration cases. However, some people may say, well, my firm may not have, an arbitration department, and well, should I be upset about it? I don't think you should, because for the law firms which have litigation or dispute resolution practice, from time to time, there may be arbitration cases going to the firm, and you should make use of that opportunity to, work in arbitration to gain more experience in that area. So I think that is also another way for you to have a taste of arbitration. This is the first way to get in a law firm and work in arbitration area. And the second way, just like Diana said, it's not just private practice. You can work with an arbitration institution. You may work in the government and also in some NGOs. For the arbitration institutions, they have some openings called case managers and counsel. What they do, actually, they are there to administer and to manage an arbitration case. And if you work as a case manager and counsel, you will be able to, work in that and see the progress of the whole case from the very beginning to the end. When you receive the notice of arbitration from a party, towards the end, when the final award is published by the tribunal. So you will also help reviewing the documents lodged by the parties to see whether they comply with the rules and the procedures. You will have the opportunity to assist the arbitrators to see how arbitrators deal with the cases. So also another function of the case manager and the counsel is that the institution, the arbitration institution, they maintain a panel of arbitrators, and they may have the opportunity to, appoint arbitrators to the tribunal based on the arbitrators' experience, qualifications, and availability. They will help in that process. Other than that, the other way to work in the arbitration area is to become a tribunal secretary. Arbitrators, they are, sometimes they are very busy. They have, other practices, and they need someone to help them to deal with the administrative work. So that's why sometimes the tribunal, the arbitrators, they would propose to the parties to, ask them to agree to engage a tribunal secretary to assist the work of the arbitrator. The tribunal secretary, they will help organize the tribunal's diaries schedule to prepare and distribute documents and communicate with the parties. And sometimes they will help the tribunal to draft some documents. So if you work as a tribunal secretary, you will have the first-hand knowledge of the entire arbitration, and you have first-hand knowledge to assist the work of the arbitrators, to support the arbitrators on a day-to-day basis. So through that, you will develop the expertise in document management, witness handling, award drafting, and document drafting as well. And I think that is also a very valuable way for the young practitioners to have a taste on arbitration. And the other way for you to start a career in arbitration is just like what David has said, to attend the arbitration conferences and events. They are free. Sometimes they charge a little bit of money, but I think they offer a very good opportunity to the young practitioners to know the current trend of arbitration, the knowledge of arbitration, the development of the law in arbitration. I think they are valuable. And by attending those events and conferences, you will have the opportunity to make new friends, to meet with the prominent practitioners in the area. Sometimes you may be able to meet your mentor. Sometimes you may be able to get a job in arbitration. Who knows what will happen? Yeah. And the other way is to join a professional arbitration body like CIAC, Charter Institute of Arbitrators, and also some organizations and institutions mentioned by David earlier. And I think through that professional network, you will be able to build your own brand, to promote yourself, and establish your own reputation. I think they are all very useful, and I hope the law students and young practitioners they may consider those options to develop their career in arbitration. Okay, and the second topic I'm going to talk, in this sharing is the advantages for Korean lawyers to work in international arbitration area. Um, you know, Korea has been, developed a lot over the past several decades, and there are many, many um, big, um, big corporations, Korean corporations. They play a very important roles in various areas like energy, like automobile, like technology, etc., etc. In other words, the Korean corporation, they will have more and more opportunities to get involved in international arbitration when they do business with other countries in the world. And therefore, they may, in the contrast, propose to adopt Korean law, and they may, choose to resolve their disputes by arbitration. And I think that provides a very good opportunities for the Korean lawyers to work in that area. Even if the contrast may say the arbitration is to be conducted in other, other cities, they may also, the contract itself may be governed by Korean law, and therefore Korean lawyers will also have a role to play in that context. And also, as the opening speaker has mentioned, they set up their international arbitration practice decades ago, and I think more and more Korean law firms, they are aware of that trend, and start to develop their arbitration practice. And I think with more and more Korean lawyers to practice in that area, it will no doubt strengthen the entire arbitration practice in Korea. And the third thing is I'm aware of the efforts and the rapid development of KCAB, Korean Commercial Arbitration Board. They organize many conferences, events, and also they are working very hard to promote Korea as an arbitration seat. And I think with a stronger and stronger practitioners, Korean practitioners in this area, it will help Korea to position itself as a regional arbitration center, especially when Korea companies are involved in those areas. And finally, I would like to take this time to promote Hong Kong, because Hong Kong is also one of the very popular arbitration centers. And what I'm going to say is that Hong Kong, we have a very pro-arbitration legal system. The courts, they are very supportive to arbitration. And Hong Kong also have a pool of experienced arbitrators, lawyers, and professionals. And Hong Kong is a doorstep to mainland China. And other than that, it is easily accessible from all East Asia's major commercial centers. And I think that is one of the attractions of Hong Kong as an arbitration center in the region. And also the awards made in Hong Kong, they are enforceable in many, many jurisdictions in Hong Kong. Bear in mind, Hong Kong is a party to New York Convention. And other than that, we have a special arrangement with mainland China, whereby we can, once you start an arbitration in Hong Kong, and if the the counterparty is a mainland China entity, you will be able to seek interim measure from the China court to help you to preserve the assets of the China counterparty in China. I think that is a very unique advantage of Hong Kong as an arbitration center. So thank you so much. I'm aware of the time, so I will keep the sharing short. And thank you very much.
Thank you, Justin. We have a question from the audience. Could you briefly discuss the difference between working at a law firm, an arbitral institution, or an NGO, as you've mentioned, as several pathways for careers in international arbitration?
Okay. Working with a law firm, you will be the counsel, the lawyer representing your client to present your case in the arbitration. So you work from that perspective, working for the client, present their case in the arbitration. But if you work as a case manager or counsel, you are working from another perspective. You are working with the arbitration institution. You manage the case. So the function is like a case management function. You administer the arbitration. But the good thing is that you will have the opportunity to interact with the arbitrator. You know, you may know what the arbitrator thinks. And in the meantime, you will also have the opportunity to see the documents submitted by the parties' legal representatives. So you will have a more holistic view of that. Once you have the insight of how the arbitration institution works, it may be an added advantage if later you go out and work with a law firm to represent clients in arbitration. You can promote, you can tell the clients that, well, I have the insight working as an, counsel or case manager in the institution. So I think it has an added advantage in that perspective. And also, if you work in the arbitration institution, you have more opportunities to, see and, interact with other arbitrators in the panel. I think that's also another advantage of that.
Thank you, Justin,
Thank you.
for your very helpful comments.
Thank you.
Finally, we have Mr. Yongwei Chen, who will share his insights with us. Yongwei, the floor is yours.
Thank you, Ms. Lee, and hi, everyone. I wish I had the benefit of a session like this before I started practice a number of years ago, because there's so many insights from my co-panelists that I find equally applicable to me even now at this stage of my career and in fact of my life. So coming at the end of this session and having an eye towards adding value, I thought I should focus a bit more on a specific topic, given that my co-panelists have already shared their wisdom on the general principles and lessons that I think everyone here should bear in mind when starting a career in arbitration, or in fact in any other area of law. My topic builds on a theme already introduced by Mr. Yuen. It's about gaps and overlaps between litigation and arbitration. Put another way, my thesis is that starting your career in litigation can provide a great foundation for a career in arbitration. And I thought this would be relevant because there are probably many more opportunities to join a litigation team out of law school compared to opportunities to join a team that is focused purely on arbitration and nothing else. Or you might find yourself in a more general, disputes resolution department where you handle a mix of litigation, arbitration, investigations, and whatever else might come across your desk on a given day. I mean, you should obviously embrace any opportunity to work on arbitrations and arbitration-related matters, but you should not be disheartened if you end up working on many more litigation or litigation-related matters than arbitration cases as a junior or in the first few years of your career. There are several benefits to joining, or rather to starting out as a litigator before transitioning into arbitration. I'm not entirely sure how it works in Korea, but in other common law jurisdictions like Singapore, one of the benefits of starting out as a litigator is that you get a lot more opportunity for advocacy at an early stage of your career compared to starting in arbitrations. That's primarily because in litigation, there are far more interim and interlocutory hearings, procedural conferences, and depending on the culture of your team, as a junior, you may get many more opportunities to appear in court, even in the first or second years of your career. I had the fortune or misfortune of arguing an appeal before a judge in the first year of my stint at a litigation firm. It was terrifying, but it was also an incredible opportunity and a way to build confidence in advocacy. This is a theme that I think Ms. Shao touched on as well, that litigation experience, even just going along to court with the rest of your team and sitting there and watching your colleagues argue and present cases that you researched and points that you helped to develop before judges, before junior judicial officers, can be an incredible learning opportunity. And it is just in the nature of things that there are far more hearings in litigation than that tend to be in most arbitration or arbitration-related matters. Arbitration also inherits or shares many concepts of litigation. Concepts like document production, security for costs, other procedural mechanisms are very similar. And so you learn about them either way, whether you start off in a litigation team or you start off in a pure arbitration team. Other core skills like project management, attention to detail, work ethic, you will pick these up just as quickly in litigation as you will in arbitration. And very importantly, the core lesson of failure and failing over and over again, something that Mr. Kim touched on. You don't have to worry about missing out on that in litigation. You will get that in spades in, I think, any area of practice as a junior lawyer. There are also key differences between litigation and arbitration. Things like how procedure tends to be a lot more rigid in litigation and a little more flexible in arbitration. The ability to select your tribunal in arbitration, I think, is a core feature that you won't really get in litigation. I don't think you get to choose your judges in most jurisdictions in the world. And that requires a completely different skill set if you want to be an arbitration lawyer. You need to be familiar with the profiles of the arbitrators out there, the ways different arbitrators approach cases differently, and being able to think critically about what type of arbitrator you want on your case is something that you will probably not get much exposure to as a litigator, though that is not in and of itself a reason to be, as I said, disheartened if your first stint is in a litigation team. Another important difference is how in arbitration, both the tribunal as well as the parties' lawyers are frequently thinking ahead to the risk of having the award set aside, and they are conscious of whether what they're doing during the course of the proceedings is laying the groundwork or leaving the door open for that as a possibility or not. In litigation, yes, people do think about the possibility of an appeal and whether they are taking points at trial or at first instance that would allow them, to raise them on appeal if required. But again, it's a slightly different skill set, slightly different considerations are involved. Appeals may be brought on the basis of an error of law, whereas under most arbitration regimes, a pure error of law is not a basis on which you can set aside an award. And so again, slightly different skill sets, but I think the one takeaway from what I'm saying is that starting in litigation, as I did, I was a litigator for 8 years before transitioning into a more arbitration focused team, can be a great way to start your career. And so it's something that, you should seriously consider. And that's it from me.
Thank you, Yong. I also personally remember when I was in law school and was doing an internship at SIAC, I was surprised to find that some professionals who are already working in international arbitration mentioned transitioning from another field and then into arbitration. But I think when you actually make the crossover, a crucial aspect is finding the right timing or the milestone for that shift. Do you have any personal advices or tips on how to make that shift?
That's actually a very good question. And I think The one downside or one common issue that many litigators may face when transitioning to arbitration is that they then start treating every single arbitration like a litigation. They take every single procedural point. They insist on extreme rigidity when it comes to the timetable. They are not sufficiently plugged in to international arbitral practice to recognize that, some of the ways in which you approach issues like, say, interim applications, injunctions, might involve a slightly different test or a slightly different set of considerations. So I don't want to, and I shouldn't provide a strict timeline, like say, get out of litigation after 3 years, or if you haven't moved to a pure arbitration team in your 5th year, you're stuck in whatever it is you're doing for life. That would just be too prescriptive. I think what's more important is to keep your finger in the pie, keep involved in the arbitration circuit, go for the conferences that my other co-panelists mentioned, join the international associations that they mentioned, keep involved. Don't silo yourself into one way of thinking. And when the opportunity comes, ask yourself, am I still interested in arbitration? And if you are, then jump with both feet. You will rarely, I think, in this day and age, be able to dictate when exactly you want to cross over into arbitration. Opportunities are often few and far between. And so perhaps the piece of advice is more of being ready to jump as and when the opportunity presents itself.
Thank you very much, Yong, for your wise advices. This brings us to the end of our session. I'd like to extend my sincere thanks to our wonderful panelists for their time and for sharing such valuable advices. I'd also like to thank our audiences for tuning in and participating with your live questions. If you have any additional questions, please feel free to reach out to us directly. I'm sure our panelists would be happy to share their experiences. And thank you, and back to you, Sam.
Gratitude to Mr. Kim, Ms. Shao, Mr. Yuen, Mr. Chan, and our moderator, Ms. Lee, for the vibrant discourse and insightful tips for students and younger practitioners. I was so busy taking notes throughout the session that I almost forgot I had to host this webinar. Thank you again. And this now concludes today's webinar. The insights today have been both enriching and enlightening. I cannot thank our speakers enough for all they have shared today. As we end, please join me in extending a special appreciation to Peter&Kim, In-Soo Choi, and Chang Yun-Oh, our team, host committee that made this event possible. We also express our greatest gratitude to Professor Joon-gi Kim of Yonsei Law School for his unwavering support throughout this journey. Above all, we sincerely thank every one of you in the crowd for joining us today. You are YAD. We eagerly anticipate your presence again next year for YAD 2025. Until then, thank you and goodbye.